Welcome everyone. Thanks a lot for staying with us. You're watching Plain Speak with me, Shivani Gupta. The centre has come out defending the much maligned Citizenship Amendment Act 2019 with its affidavit filed in the Supreme Court of India. This is in response to multiple pleas filed against the Act. While the implementation of the Act continues to be in limbo, the legal battle is finally picking pace after 2 years on the back burner. And this legal fight will be critical for the future of this legislation. The government's mind has already been known, but this affidavit provides legal, detailed defense of the Act, and on every count that the CAA was opposed, the centre has defended it. On the question that it is discriminatory, that it will lead to influx of foreigners, or even the exception made for some areas in the Northeast, importantly, the question that is often asked is, if this is about protecting victims of prosecution, then why not all victims, even Muslims from these three Islamic neighbouring countries? To this, the centre has said that the CAA does not seek to recognize or provide answers to any kind of persecution that may be taking place across the world. That it is a narrowly tailored legislation seeking to address a specific problem and should not be tested on any other touchstone. The CAA backlash, remember, produced some of the most vicious and violent protests in India in recent times. Were these protests premature, misinformed, or driven by agenda? These are questions we have continued to debate. And now, post the government's firm stance in court, we ask these questions again. Where is the scope exactly to oppose the CAA? And can there be political consensus on the legislation that is already passed by Parliament? I will take these questions to our guest joining us in just a bit. But first up, let me break down what the centre has told the Apex Court in detail. So defence number one, that the CAA is a benign legislation. It seeks to provide a relaxation in the nature of amnesty provided. And who is that nature of amnesty for? Specific communities from specified countries, in this case Pakistan, Afghanistan, Bangladesh, with a clear cut-off date. Defence number three, that it tackles a specific problem of persecution on the basis of religion in these theocratic countries. We all know they are Islamic theocratic countries. And it doesn't seek to solve, as I said, the issue of persecution per se overall. Defence number four, it does not impinge upon any existing right prior to the new law. A lot of misinformation was spread, remember, that Indian Muslims specifically will lose their citizenship because of this law. Defence number five, a narrowly tailored legislation seeking to address specific problems. 6, it seeks to address the problem that has awaited India's attention for decades. Remember, these refugees that this seeks to give amnesty to have come to India for obvious reasons as their historical motherland. And given partition, India has a specific responsibility and duty to these refugees. Defence number 7. In no manner does this affect the legal democratic right of Indian citizens. In fact, it doesn't pertain to Indian citizens at all. The centre also goes on to clearly mention that CAA only makes eligible class of foreigners who took shelter in India on or before 31st/12/2014. So that's the clear cut-off date. Those who took shelter due to persecution faced in these three countries on grounds of religion. No provision to provide citizenship to such migrants who came after this date of 2014. So CAA does not encourage any future influx of foreigners into India, is what the centre has said. The CAA applies to past events and has no application in future. And it's not like no one else from these countries or other countries will be able to take Indian citizenship. Another misinformation which was spread. Like the centre response states, existing regime for obtaining citizenship by foreigners of any country, including these three countries, is untouched. So legal migration on the basis of valid documents and visa for whatever reason, including religious persecution, from these three countries, apart from these communities which are non-Islamic minorities in these countries, continues to be permissible. So what's the problem? Who's being barred? Interestingly, the centre also sought to remind the court of limited jurisdiction, quote-unquote here. It said, judicial review in the matter would be very restrictive and limited. And why? It said so considering wider width of legislative policy and wisdom. In other words, I think the government has gone on to tell the court that this is really the domain of the legislature to make these changes. And if the opposition is that it is unconstitutional in any way, then it has to, of course, been provided for. It has to be explained. So the big question we're asked today is exactly this. The centre is defending the Citizenship Amendment Act in the topmost court of the country. So the question is, can there be a consensus over this law? Because, you know, this is already passed by Parliament and many communities are waiting for it to be implemented. Let me first go across to to Abhishek Manu Singhvi, who's the third time sitting MP, chairman of Parliamentary Standing Committee, and an eminent jurist. Manu Singhvi is also one of the petitioners who has challenged CAA in the Supreme Court. Mr. Singhvi, thanks a lot for your time. I begin by asking you, given the government's detailed response on the pleas against CAA, what is the argument according to you to still deem this act unconstitutional?
Let me start by saying firstly that precisely because I am one of the lead counsel, I don't really want to discuss the merits in the way you want to, because I am a counsel and I don't think it's right for me to discuss it. We can't have the court battle outside of the court on media. Second, today was a housekeeping hearing. It's good of you to try and educate your viewers, but today was a housekeeping hearing. And third, in that housekeeping hearing, it emerged that after months, despite a deadline given to the government of India to file appropriate responses on affidavit, they took time, and the order so records, having not filed in time. The learned Solicitor General said so. And I think the urgency of the whole matter was appreciated by the bench, which said that they should have filed earlier, but nevertheless now gave time on the 6th of December. Fourthly, without going into the merits in an argumentative sense, let me tell you that a lot of issues. Before that, let me also add that there cannot be this kind of a question, why can't there be a consensus on the law? There is a law passed. Obviously, the law is passed by majority. Obviously, the majority law prevails. It's the law of the land. But equally, you must understand the mechanics and the system. It is under challenge in the court of law.
Sure.
Now, there's no question of consensus in the court of law, because in a sense, you'd be suggesting that either we withdraw the challenge or the government changes the bill.
No, that consensus debate is for my other guests who will be joining me, politically speaking, after the government's very stated response.
There a consensus, as you put it in your question. This will be either upheld by the court, it will be either partially struck down, or it will be wholly struck down, and in that sense modified by the court depending on what view they take. But now coming to your question on the merits, all I'd like to say is that there are serious issues of constitutional law arising.
Right.
To give an example, one issue is clearly of classification. Can you classify in a manner which is geographically limited, applies only to a few countries? The Tamilians today raised an issue about Sri Lankan Tamils. How included them? There was an argument today by counsel for the Tamil Nadu government. Apart from geographical classification, the other is a issue of religious classification. Can you have a law so tailored which draws a line, firstly geographically, excluding some from the line, including some. Similarly, a second line religiously, excluding several religions and giving the benefit to several other religions. Now, the test in law is that such lines can be drawn only if there is a very reasonable, very transparent nexus with the object sought to be achieved. Now, one object stated by the government is that you have minorities in the stated countries, and they comprise mainly Hindus and other similar minorities. But equally, there are large segments which are in other countries, minorities which are not included. There are Ahmadiyas, there are, other Shia groups, as somebody said about Tamil Nadu. And there are different countries which have suffered on this account, which are not included. So the ultimate bottom line would be for the court to decide whether the geographical line drawn, whether the religious line drawn, bears a reasonable nexus to the object sought to be achieved.
Okay. Sir, can
and
I
then
come
there
in?
are also issues of Tripura, in particular, from Bengal in particular, which are a second segment of the case. So I think there's a lot to be dealt with. The government, in fact, has not filed full replies on time. And I think we look forward to the hearing on 6th or shortly thereafter when the hearing will commence.
Well, we do hope that, of course, the legal battle will now pick up pace, because everybody wants an end to this matter. As you said, it will be decided one way or the other. But on the issue of classification, I just, for the benefit of my viewers, do want to mention that the government has quoted Article 6 of the Constitution, which had initially allowed migrants who came into India from Pakistan, including present-day Bangladesh, as citizens till a cut-off date, and even those who had come after 6 months or had been resident in India for at least 6 months before the date of registration, even those citizens were allowed to be deemed Indian citizens. So there is a special class of migrants post-partition, which clearly took on the basis of religious lines and resulted in large-scale migration on religious lines as citizens of India due to very special circumstances. But I move on. You don't want to, of course, talk about the legal angle here, because this is going to be debated in the court. I want to ask you, Abhishek Manu Singh, fundamentally those opposed to CAA, how will they justify their stand given the hardships religious minorities, particularly Hindus, Sikhs, etc., face in these neighbor countries? And especially when CAA clearly doesn't take away anything else from an Indian citizen, even the other persecuted minorities from the Muslim communities in these countries can come to India on a case-to-case basis. You are one of those people who has talked about the plight of Hindus, Sikhs and others in these countries. How do you justify politically, in a civic manner, the opposition to this act?
I don't think any of the challenges is to the inclusion of Hindus or other minorities like Sikhs. It is to the exclusion of other groups. Nobody is suggesting that the inclusion of certain minorities in those respective countries is wrong. What we are saying is that that is a partial inclusion. The ambit must be expanded. Secondly, the test is not persecution, which might have been a valid test, as, for example, refugee law provides. The test is purely religious, only selected minorities in those countries, leaving out many, as I said, or the test is purely geographical. There also the boundaries are drawn very arbitrarily.
The government says that even if they apply these persecuted religious minorities, there is a process. It's not like willy-nilly it is given to anybody who may come.
Absolutely, but this particular amendment, you're right, the amendment gives it in a large sense to those who establish their status, but the qualifying condition is merely religion.
While but are Muslims who are religiously or otherwise persecuted in these countries on the same plane as religious minorities like Hindus, Sikhs, Buddhists and others? Are they on the same plane?
No. There are, first of all, many minorities who claim persecution. I give you two examples. Subsects of Shias, Tamilians, the Rohingyas. There are so many more. Those are not addressed. I can understand there's a mechanism to say we will address them, but there is a per se exclusion. Secondly, you see, in the name of the CAA, do you know the actual thing on the ground? Tripura and Assam are two major petitioners because the actual result on the ground has been actually loss of citizenship. It has been because you are occasionally for political rhetoric or otherwise, but frequently combining it with national registers of citizenship. You are excluding large numbers of people who may have been actually settled here. So this whole thing comes as a package.
Okay.
And you can't disentangle the NRC from the CAA or vice versa.
I'm not going to go into that because I don't have really the government's position on that as far as this affidavit is concerned. But that's really not an argument against this act per se. And that brings me to my final question to you. You have also said that there is anger, fear and mistrust amongst the people and the centre is responsible for creating such an atmosphere among them. But my question to you is, let's say there are fears over NRC and CAA combined, national register, etc., plus what you've talked about. There are other ways to address that. Are we not throwing the baby out with the bath water to ask for the CAA itself to be cancelled?
On the contrary, I would say that in a functioning democracy of which we are proud, India, in a functioning constitutional system, the most dynamic in the world, in a system where we have very bright and very dynamic judiciary, the correct way is to throw up a legal challenge. That is totally democratic, that is totally constitutional. How can you suggest that there should not even be a challenge? There are people who have grievances, they may lose, they may win, but the ventilation of those grievances by established democratic processes is in fact a catharsis for democracy. It is in fact the right outlet for democracy.
I have no objections to the legal opposition to this case.
To try and suppress that or try and prevent that itself would be an outpouring of grievance. So I think the right thing is this, and as a matter of fact, this challenge should have been heard months or years ago.
Okay.
But now that it is coming up, we should welcome it. Why should you say that let there be a consensus, let the challenge not go on, let the challenge be withdrawn, let the challenge be thwarted or settled?
I'm not saying that the challenge should be withdrawn. Of course, the legal battle should go ahead. We all welcome the fact that it is finally picking pace. But I've run out of time. Abhishek Manu Singh, thanks a lot for joining us and sharing your opinion with us. Let's take this to our other guest joining us. Anila Singh of the BJP is now joining us. We are expecting a Congress representative soon as well. But I think Abhishek Manu Singh has in fact given the viewpoint of the Congress party Its state association is also one of the petitioners against the case. Ratan Sharda of the RSS and Champak Kalita of the AIUDF General Secretary. Kapil Sankla is senior Supreme Court lawyer who's joining us. Let me go across to Ratan Sharda first up. You heard what Abhishek Manu Singhvi said. He said that everybody who's religiously persecuted should be allowed entry via CAA. I know that the government has said exactly the opposite, and the argument against that also is that everybody is not on the same plane when it comes to giving this very focused, limited amnesty to refugees of a certain religion, persecuted on the basis of religion, and who have already come to India till 2014. How do you respond? Because this is the biggest argument that is used, that why not allow all people persecuted?
Shivani, I have the luxury of not being politically correct, and I do not need to pull punches. India was partitioned on the basis of religion. Dr. Ambedkar at that time had said that there should be exchange of population, otherwise the problem will remain festering. Secondly, Nehru Liaquat Pact about what? That they will take care of minorities, we will take care of their minorities. It did not happen.
True.
Now, what is the view of people? I'll quote some of the things. I can't quote too much, there's not much of a time. Mahatma Gandhi in July 1647 said, the duty of adjoining province on the side of border will be to accept them with both arms and extend to them all legitimate opportunities. Then he said, poor Hindus who will migrate owing to repression will certainly be accommodated in India. In November 5, Jawaharlal Nehru assured in Parliament, there is no doubt, of course, that those displaced persons who have come to settle in India are bound to have citizenship. If law is inadequate in this respect, the law should be changed. So, having an Islamic country of their choice, today to cry persecution being minority within minority is not acceptable to us, because they chose. There is huge cost we paid for that particular Islamic country, a third one which has become Islamic now. So where do the minorities give? They've been wiped out totally.
Yeah.
You know what happened in Afghanistan, you know what is happening in Pakistan. Every day there is atrocity news. Bangladesh, every day atrocity news. Where will those people go? So when the partition was a religious ground, when people are being persecuted on religious ground, law will have to be in terms of religion. Secondly, there is second option still available. Have we stopped migration with us? No, sir. The earlier law of granting citizenship is still available. So why are people saying we have been discriminatory? Third, who are the people who are fighting the CAA? Congress, TMC, Muslim League, RJD, MIM. Look at the company they have. We have electricity for Rohingyas in Delhi, but you don't have electricity for Hindus in Delhi. The same refugees. We had 1 million Hindus rotting in Jammu Kashmir for 70 years because they did not get citizenship there, neither here nor there. And if you look more at people, then there was Gulzari Nanda, there was CPIM, there was Manmohan Singh, there was Tarun Gogoi. Everybody said that please accommodate our unfortunate Hindu refugees. Having said this, why are they going on that? Law will be tough, law will become difficult, but to add it on to NRC and say this is not right, that is not right, when entire base of persecution of people is on ground of being minority, Hindu, Christian or Sikh, then how can you say your law cannot be minority?
So you are saying that if you bring up the case of Ahmadiyas or, for example, Shia minorities, they don't sit on the same plane for them to require a CAA-like legislation.
Shia Ahmadiyya played a great part in getting India partitioned. Let us not forget it. I have respect for them. I have sympathy for them. But it is like, partitioning of a parent's house, taking another part of the house, then saying, oh, that house is not good enough, I want to come back. So they have to pay the price for that.
The point is that even individually, even if from these countries, an Ahmadiyya persecuted individual or a Shia persecuted individual wanted to make India their home, that option is available to them. Nobody has been barred. I say this because when the CAA first came out, this was one of the biggest things, or possibly a misinformation that was spread, or it was, people believed it. They thought that would be the case, but that isn't the case. Shouldn't we revise our position on CAA? And that's why I talked of consensus. But you mentioned the company of the people who have objected to this legislation. Let me bring in Champak Kalita of the AIUDF. The centre has also gone on to mention very clearly the exceptions that have been made for northeast regions, and they've justified those exceptions because they're saying this is based on historical lessons, etc. What is your objection to the CAA when it hurts nobody in India? Certainly no Indian minority.
In English, मैं हिंदी में बोलूँगा. देखिए, सबसे इस पे दो चीजें आपको देखना पड़ेगा. एक नेशनल परसेप्शन में और एक रीजनल परसेप्शन में. सबसे बड़ी चीज है जो कॉन्स्टिट्यूशनल मैटर है, ये जो सुप्रीम कोर्ट में जाएगा तो ये खारिज इसीलिए हो जाएगा कि ये सबसे बड़ी बात है कि भारतीय संविधान ये अलाउ नहीं कर सकता कि भारत में शहरियत मिले, सिटीजनशिप मिले, उसके लिए क्राइटेरिया रिलीजन हो। ये सबसे बड़ी चीज है। मतलब ये कभी भी सुप्रीम कोर्ट अलाउ नहीं करेगा। आप इसको माइनॉरिटी कर दीजिए, कुछ अलग कर दीजिए, अलग बात है, परसिक्यूटेड पीपुल कर दीजिए, लेकिन भारत में सिटीजनशिप, शहरियत मिलने का मयार कभी भी मजहब नहीं हो सकता। ये कभी संविधान का जो सबसे बड़ा कोर्ट है वो नहीं मानेगा, पहली बात। दूसरी बात, ये आसाम के लिए अलग है। आसाम में आपका 1979 से 1985 तक 6 साल एक बहुत बड़ा आंदोलन हुआ, और उस आंदोलन को स्टेट, इंडियन स्टेट के साथ एक अकॉर्ड हुआ जिसको बोलते हैं आसाम अकॉर्ड, आसाम चुक्ति, आसाम समझौता। तो इंडियन स्टेट ने आसामीज कम्युनिटी को कमिटमेंट दिया कि ये है आपका डेडलाइन 1971 25 का मार्च से पहले, बाद में जो आएगा वो फॉरेनर्स है, पहले जो है वो यहाँ रह जाएगा। लेकिन ये CAA उस कमिटमेंट को ब्रेक कर रहा है, इसीलिए आसाम में इतना रिएक्शन था उस समय। अब भी है, अब टाइम गया है, लेकिन मैं आपको बोलता हूं चीज यही है कि दो चीज, एक भारत का संविधान या भारत ऐसा एक स्टेट नहीं बनना चाहता है कि इसका सिटीजनशिप का मेयार रिलीजन हो।
Okay.
और दूसरा,
गवर्नमेंट ने जो आज कोर्ट में बोला है वो ये बोला है कि सिटीजनशिप के जो रूल्स हैं, जो एग्जिस्टिंग रूल्स हैं, उसमें कोई बदलाव नहीं है। ये एक बहुत नैरो, फोकस्ड और लिमिटेड एमनेस्टी है एक सर्टेन सेक्शन ऑफ पीपल के लिए, और ये पार्टीशन की बहुत स्पेसिफिक हिस्ट्री की वजह से वो क्लास ऑफ माइग्रेंट्स और रेफ्यूजीज इंडिया एक्नॉलेज करती है, पार्टीशन के बाद भी एक्नॉलेज किया था, और अब भी जरूरत है एटलीस्ट टिल द 2014 कट ऑफ डेट दैट द गवर्नमेंट हैज डिसाइडेड। बट आई डू वांट टू से दैट ऑन द इशू ऑफ द नॉर्थ ईस्ट, on the act exempting specified areas of Assam, Meghalaya, Mizoram and Tripura as included in the 6th schedule, the government, or the inner line as it is mentioned, the government has said that these specifications or exclusions have been made on tangible material, historical reasons and the already prevalent classifications and cannot be said to be discriminatory. But I want to bring in Kapil Sankla on the prominent point that Champak Kalita is making, that no sub-classification even on the basis of religion that grants citizenship retrospectively or otherwise can be made on the basis of religion. Do you think that opposition alone is going to be heavy on the entire CAA Act?
I honestly don't think so, and I've already spoken about this, and I'll tell you why. Because I think the narrative that has been said is incorrect. It does not give citizenship and it does not take away citizenship. What it basically does is, to a certain segment of people, it fast tracks citizenship. And that is nothing new. When you look at it internationally, I mean, imagine this, that there would be a political refugee, any country will probably fast track citizenship for him. America does it. When you talk about brain drain, highly educated people, well, certain countries accommodate them, fast track citizenship. When you talk about, for example, people who have the money, they can 10 crore or 2 crore or 4 crore. Certain countries fast track citizenship. What you're saying is that there are minority refugees who we allow to fast track citizenship, looking at the conduct of the country from where they are seeking refuge from. And that's something that every international country all over the world does. I said America does it. It fast tracks citizenship when you're a political refugee.
But on the basis
or
of religion,
because of
Kapil Sankla?
XYZ reasons. What we said. That's exactly what I'm saying. What you're basically saying is that there is a religious minority which is in 3 or 4 countries. Should they seek citizenship, we can fast track it. It does not open up citizenship for them, dehorse or disconnected from other religious groups. It just fast tracks citizenship, and that is the difference. So the narrative that is being said that, the Muslims will not get citizenship is incorrect, because according to the Act, the Foreign Act, there is a waiting period of, I think, 7 years. The citizenship is still granted. What this just says is that it fast tracks it to, I think, 5 years or 4 years. Or
yeah, even that has become infructuous, no, Kapil?
And that is
because the deadline was till 2014.
Yes, you're.
So now I don't know on what basis was it going to be opposed. Because already these people, have been in India for many years.
And that And that's exactly what I'm saying. So it actually takes care of past events and not a subsequent act.
Yeah.
And therefore, as you rightly said, that even that argument is now infructuous. So I really don't know what kind of narrative is being sought to be created by the side opposite.
So can I ask you a focused question? The government, I think, has very importantly also reminded the court that, listen, there is a limited scope of judicial review here. And from what I understand, you can correct me, unless a law can be deemed unconstitutional, the courts cannot strike it down. In this act, what is the scope to prove CAA unconstitutional?
You're absolutely right. You see, there are 4 pillars of democracy. Media is one, judiciary, executive, and the legislature. The democracy, yes, the legislative. The democratic system is that not only you do not have a adventure in encroaching on somebody else's power, but you also respect the different pillars of democracy. And therefore, the government, being the legislative, having come up with the law, unless and until said to be undemocratic, cannot be challenged. In this case, there is nothing undemocratic that has been shown or against the constitution. As I said, the narrative that is said that the right of the Muslims is being taken away is incorrect. It just fast tracks it for a certain minority groups internationally. That's it.
Okay, so you don't think there's anything unconstitutional as far as this law is concerned?
Absolutely not. Absolutely not.
I think Mr. Kalita wants to come in. Can I just listen to him for 30 seconds, then you can respond? Yes, Champak ji?
देखिए मैडम, यहाँ मुस्लिम इंक्लूशन, मुस्लिम को भी वहाँ लिस्ट में नाम लगा, वो ये वाली बात आई नहीं है। यहाँ बात ये हुआ है कि हम ये इंटरनेशनली ये मैसेज नहीं दे सकता है सुप्रीम कोर्ट कि भारत में सिटीजन का क्राइटेरिया रिलीजन है। आप उसको अगर 14 का है तो आप ये आइन बनाइए कि 14 तक जो प्रोसिक्यूशन होके लोग आए हैं उनको हम सिटीजनशिप दे रहे हैं। इसमें रिलीजन का क्या काम है? इसीलिए ये अनकॉन्स्टिट्यूशनल है, ये सुप्रीम कोर्ट में इजीली उठ जाएगा।
अच्छा, I want to go across to our BJP representative.
इन्हीं की भाषा में रिस्पॉन्ड कर दूं?
हाँ जी, कपिल जी बोल दीजिए।
एक लाइन में सिर्फ बोलता हूं मैं, इन्हीं की भाषा में बोलता हूं कि सर, पॉलिटिकल रिफ्यूजी ऑल्सो रिलीजियस रिफ्यूजीज होते हैं। अगर किसी देश में पॉलिटिकल कारणों से, जैसे पाकिस्तान में हो रहा है और अलग देशों में हो रहा है, एक सर्टेन माइनॉरिटी जो वहां की माइनॉरिटी है उसको प्रोसिक्यूट करा जा रहा है, तो कोई देश उनको शय दे सकता है। हमारा देश भी वही कर रहा है। तो इसमें कोई अनकॉन्स्टिट्यूशनल या इलीगैलिटी नहीं है। सर, जब मैं आप बात कर रहे थे तो मैं सुन रहा था, अब आपको मेरी बात सुननी पड़ेगी। आई एम सो सॉरी सर, व्हेन आई एम टॉकिंग सर, अलाउ मी टू फिनिश। यू कैन गो ऑन एंड ऑन सर, बट आई डू दिस प्रोफेशनली, एज आई सेड, जस्ट लेट मी फिनिश। तो जब आप एक आदमी को पॉलिटिकल रिफ्यूजी बोलते हो, पॉलिटिकली किसी आदमी को या किसी ग्रुप को अगर रिफ्यूज चाहिए तो कोई भी देश अपने दरवाजे उनके लिए खोल सकता है। वही हमारा देश भी कर रहा है।
And also, let's not forget here,
में 14% से 1% हो गए, 14% से अगर 1% हो गए हैं,
these are special circumstances. Let's not forget that these were all countries and regions of undivided India. There's a specific history here. We are not doing this for for Japan or for China or for US or for UK. We have a certain responsibility in the subcontinent. We signed the Liaquat Pact on that. If Pakistan and Bangladesh didn't stand true to their promise, India as the basic motherland of these countries has a responsibility. And the partition also happened on the basis of religion. We would all like to... Champak ji, ek second, mere upar mat boliye. We would all like to live in the utopia where religion doesn't matter, but let's not forget the partition did take place on religious lines. It didn't take place just on geographical lines. Please, let's accept that reality. I've limited time now. Two of my guests have not spoken. Advocate Mahima Singh, I beg your pardon, from the Congress has joined us belatedly. I've run out of time mostly on the debate, but I'll give you a couple of minutes. And the larger political question is, Mahima ji, how will those parties opposed to the CAA justify it to people who are till today being prosecuted, converted, illegally abducted on the basis of their religion in countries like Pakistan? You have a social responsibility here.
Shivani ji, thank you for having me on your show. Apologies for being late. There has been a technical glitch and unfortunately we couldn't help it. Finally, I'm able to contribute here to the debate, and your question is apt. And my point here is that, no, nobody is opposing guaranteeing their fundamental rights to those who deserved it rightfully. But then why are we being biased? Does our constitution provide for this bias? Does our constitution justify this bias that we see in this law? There are 6 communities that the law is providing for. The Citizenship Act 1955 was very clear. It was clear and it had an equal, prejudice, or it had an equal consequence for all the illegal migrants. However, the Citizenship Amendment Act that has come now, the 2019 Amendment Act that we see in the current form, provides for 6 communities from the 3 countries as the government
but
put it in the
don't
affidavit
these
also
6
today.
communities
However,
need greater protection? You're talking about bias. Can I
however-
just say something? Prejudice is one thing, bias is quite another. Now, there is a bias that exists in these countries against these 6 communities and members thereof. Then there obviously will be a bias in the protection and the amnesty these 6 communities get.
All right, but we're talking about the Indian citizenship and the way it is to be granted to the illegal migrants who came to this country before 2014. And why are we cornering one religion out of that? Aren't those also equally rightful of gaining
Because
that
these
status,
countries are
citizenship
Islamic
status,
nations.
as are the other? I'm saying that why are we? It is clear violation of Article 14, Article 19, Article 21, Article 25, Article 29 of the Constitution.
Okay, fair enough. I've
I'm
run
just
out of
saying,
time.
how
You
would
joined
the
us a little
government-
late. I would have liked to delve into this, but I do have to give Anila Singh some opportunity to respond to everything. Anila Singh, you've heard to the opposition that is being made to the CAA. It's a long-standing stance of several of the petitioners. They're basically saying that, one, there is some sort of an agenda that the BJP has in bringing in this legislation, and it just goes against the grain of our secular democracy. हम ये कर ही नहीं सकते कि आप religion को एक बार बनाइए.
जी, my Ram to everyone. Better late than never. After all, my turn has come. See, I'm not at all surprised. I'm not at all shocked the way Congress Party is behaving in today's date, whether we talk about CAA, whether we talk about Article 370, or we talk about Ramlala Mandir construction. They had stood like wall in between. And every time this wall had been crushed and crashed by Bharatiya Janata Party or the supporters of people who totally believe that, yes, this is one country, the majority population should have right what is correct. And Bharatiya Janata Party has always stood very strongly with it. If we talk about the Congress Party, can they deny this fact? Can they deny this fact that yes, today, like they are saying, that demographic balance bigad jayega, constitution ke khilaf hai? Like in 1947, इंडियन नेशनल कांग्रेस इन द डिक्लेरेशन डॉक्यूमेंट घोषणा पत्र में इन्होंने अखंड भारत की बात करी थी और जिन्ना ने बात करी थी पाकिस्तान की. और आज की सरकार अगर ये कहती है कि अफगानिस्तान से, बांग्लादेश से, पाकिस्तान से अगर यहाँ पर हिंदू, सिख, बुद्धिस्ट, जैन, पारसी, क्रिश्चियन जो वहां पे प्रोसिक्यूट हो रहे हैं उनको हम फैसिलिटेट करेंगे, वो भारत में आकर अपनी नागरिकता ले सकते हैं, तो दे हैव गॉट अ ह्यूज प्रॉब्लम आउट ऑफ इट. Because this is the same political party. If we talk about after partition, those all people who went into election on the ticket of Muslim League, they won the election and they didn't go to Pakistan. वो सारे के सारे कांग्रेस पार्टी में आ गए और नेहरू जी ने उनको कांग्रेस पार्टी में इसलिए रखा था जिससे कि जो हिंदुत्व मानसिकता के नेता थे कांग्रेस पार्टी में उनको कंट्रोल करके रखे. So this is the psyche of the Congress party. They are against Hindus.
Okay.
That is the
I have to leave it at that.
Classic example of twisting the narrative. Classic example of twisting the narrative. And it's shameful. Shameful. Unconstitutional, unbecoming of the government of India, unsecular.
No. Even I am secular and my party respects all religion. But if you are going to say that yes,
that shows in the conduct of the party, that shows in the conduct of the ruling party today. It is unconstitutional, it is unbecoming. It is highly unbecoming of a government that was given the mandate by the public of this country, trusting that they will protect the fundamental rights of the people of India. Unfortunately, those are the very people that are coming in between the fundamental rights of this country, the constitution, the democracy, and their own propaganda.
I think you should go and check your facts and you should check the history of Indian National Congress Party. 11th October 1947 जिन्ना से इसकी आबादी के आधार पे हम जनसंख्या की अदला बदली कर देते हैं. 12th October 1947 नेहरू जी प्रेस कॉन्फ्रेंस करते हैं और कहते हैं कि नहीं बिल्कुल अदला बदली नहीं होगी क्योंकि पूरे विश्व में हमारी बदनामी हो जाएगी. This is what
of this
Well,
give you a right to
unfortunately, I've run out of time, ladies. I look forward to having you again, and I do thank all of our guests